I want to get started, and I want to welcome everybody who's already on, and a welcome to those that are going to join and in the process of joining. I want to welcome you all to this webinar on the Carson versus Makin decision by the United States Supreme Court recently, and we're going to dig into the implications of that decision, both in the state of Maine, which it directly affects, and around the country. And first of all, I want to thank first of all, I should introduce myself. I'm David Sciarra. I'm the Executive Director of the Education Law Center. I want to thank our amazing panel today, Attorney General Aaron Frey, Assistant Attorney General Sarah Forster, our colleagues, Dr. John Jackson from the Schott Foundation and Preston Green from the University of Connecticut. They'll be introduced in a few moments. I just wanted to say that Education Law Center is coming up on its 50th year in 2023. And we are marking 50 years of work protecting and strengthening the right of school children across the country to public education. This webinar is our kickoff event. We have several events I just want to mention coming up on November 3rd. If you're a lawyer in the trenches with us, we are going to be joined by the legal team, trial team that just tried the Pennsylvania school finance case, the William Penn case. So the lawyers from Melviny and Myers, our colleagues at Education Law Center Pennsylvania, the Public Interest Law Center Philadelphia will be joining me to talk about the ins and outs of the trial, lessons learned, strategies, and so forth and so on. So if you're an attorney, this is an invitation-only event for attorneys. So if you're an attorney on our side, let us know by email and we'll sign you up and get you on. Also on November 30th, we are thrilled to sponsor an event with our colleagues at ETS and the Learning Policy Institute on Money Matters, the latest research on how money makes a difference in public education. We have an outstanding panel, Dr. Jesse Rothstein, Dr. Rucker Johnson, and our great friend, Dr. Linda Darling-Hammond will join us and ETS to talk about the latest in the research on investing in public education and how it can make a difference, especially for students of color and students from low-income families. So you don't want to miss that. That's November 30th at 3 o'clock. There will be a follow-up webinar on voucher litigation, so stay tuned for that in the beginning of the year. And lastly, on May 4th, we are going to have our 50th anniversary celebration in person in our home in Newark, and you'll be receiving information about that. So, so stay tuned for all of that. I'm going to turn it over to the moderator. Jessica Levin is ELC's Deputy Legal Director. And also she is has been leading our efforts over the last several years to combat the spread of private school voucher programs across the country, and has done a fabulous job really pushing back on the forces of privatization that are literally sweeping across the country now and diverting scarce tax dollars to private and religious schools. So Jessica, I'm going to turn it over to you to introduce the panel and get us going.
Okay, thanks very much, David. I'm Jessica Levin from Education Law Center. And as David said, I direct our Public Funds, Public Schools campaign, which is co-sponsoring this event and which works to ensure that public funds for education are used to support and strengthen our public schools. So welcome to this webinar, Post Carson v. Makin, How Can We Protect Public Education? We're here today, of course, to talk about the Carson decision, the latest in a line of Supreme Court cases that has seen a rebalancing of the religion clauses in the First Amendment, particularly but not exclusively in the realm of education, with the Supreme Court frequently giving great weight to the Free Exercise Clause and less weight to the Establishment Clause, which protects the separation of church and state. Very, very briefly, what was the case about? At issue was Maine's program to provide publicly funded education in towns that, for geographic or historical reasons, don't operate their own public schools, and Maine does that by paying tuition at private schools that meet certain requirements. And specifically at issue in the case was the requirement that these schools offer a secular education. But the U.S. Supreme Court held that the Free Exercise Clause prohibited the state from excluding schools from the tuition program due to their religious status or religious use of tuition funds. And we'll hear a lot more about the case from the experts on this panel. And we have a very distinguished panel today. Their full bios are going to be dropped in the chat for you to see all of their accolades and accomplishments, but I'll introduce them very briefly. We are really honored to have with us Maine's Attorney General, Frey, and Assistant Attorney General, Sarah Forster, who litigated the Carson case, did a phenomenal job, and are navigating the implications of the Supreme Court's ruling for Maine's students and schools today. We also have Dr. John Jackson, who is president and CEO of the Schott Foundation for Public Education, and he leads the foundation's efforts to ensure a fair and substantive opportunity to learn for all students, regardless of race or gender. And we have Dr. Preston Green, who is professor of educational leadership and law at the University of Connecticut and the John and Maria Neag Professor of Urban Education at the Neag School. And he is a leading scholar on the issues that we're discussing today and helping spearhead the effort to understand the implications of the Carson decision. So we will have time for audience questions at the end of the hour, so please feel free to put those in the Q&A box. And with that, I want to pose a few questions to Attorney General Frey and AAG Forster, and we're hoping that they can share their thoughts on some of the following. First, briefly, what was it like to litigate the case? What has been the impact in Maine so far? For example, a religious school was just approved for the tuition program. We're hoping that you can tell us a little bit about your efforts to enforce the State Human Rights Act, your anti-discrimination law, and what kind of litigation may result from that. And finally, whether there has been data gathering, studies, information about the continuing need for the tuition program, and whether there is any appetite to phase that out or to do something different from the students who are educated that way. So with that, I will turn it over to you both, and thank you.
Jessica, thank you very much. And it is really a treat to be here today with the Education Law Center, these panelists, and all of those who are joining for this really important conversation. I think it probably makes the most sense to hear first from Sarah. I mean, she has, she's been Maine DOE's attorney for a number of years and has been at the front line of this battle all the way through to the Supreme Court. And I think she might have some perspectives that are very valuable in answering those questions.
Thanks, Aaron. So this case was unusual in many ways. One way that the case was unusual is that this is actually the culmination of 20 years of litigation. And I know that those of you in the audience that are used to the desegregation cases, that are used to school funding cases, are saying, so Sarah, what's the big deal about being 20 years? That's nothing. Well, it was 20 years of litigation where the statute never changed, the Department of Education's administration of the statute never changed, and the claims of the plaintiffs never changed. Yet, in the third iteration of this litigation, the statute went from being held to be constitutional to being held unconstitutional. I think, Jessica, that might have been what you were referring to as the rebalancing of the religion clauses. So for the lawyers in the crowd, think about a case that you litigated 3 times, won twice and lost once in a period of 20 years without the statute or its implementation ever changing and without the legal claims being asserted changing. So what did we do this time that we thought at least would help our cause? Well, my colleague Chris Taub and I made a number of decisions early on in discovery that we thought would be very helpful. Remember, the reason this case had come back for round 3 was that the Supreme Court had decided the Trinity Lutheran case, where they had held that the categorical exclusion of religious entities from a public benefit program, in other words, a church was excluded because it was a church, violated the Constitution, violated the Free Exercise Clause. And so, as we were preparing our case, we wanted to push back at some of the issues that we thought the plaintiffs might bring up in claiming that Maine's tuition program was the same as the crushed tire program at issue in Trinity Lutheran. So first of all, we deposed representatives of the 2 schools that the parents wanted to send their children to, but the schools were not allowed to participate in the tuition program. And what we learned was that the representatives of these schools were extremely honest in their deposition that they weren't interested in participating in the tuition program. They couldn't be 100% sure, but they were quite certain that the only reason they would consider participating was if they didn't have to change a thing about what they were doing. And so we left those depositions thinking, there's probably a standing issue here, because the desired schools aren't going to want to take tuition dollars, even if the statute goes away. The second thing we did in discovery was we asked for a number of documents from the schools, and we got their handbooks and their employment policies, and we were clearly able to establish that both schools discriminated against both employees and students, not just based on religion, but based on gender identity, sexual preference, in other words, sexual orientation, all things that are covered by Maine's Human Rights Act, which Attorney General Frey will talk about in a bit. The other thing we did in discovery was we deposed the parents, and each set of parents told us that attending a sectarian school was not required by their religion. In other words, they could be fully consistent with their religious beliefs and send their children to non-sectarian schools. And in fact, they were. So armed with that, the plaintiffs asked us for some discovery responses. And we were asked very specifically, how do we decide if a school is eligible for the tuition program or not eligible? And we worked hard with the commissioner, the then commissioner of the Department of Education, and responded that we don't make that decision in Maine based on whether or not a religious organization operates the school. We do it based on whether or not the education program delivered is delivered through the lens or through a religious or faith-based vehicle. In other words, we're not preventing churches from participating in the tuition program. We are requiring that the education programs that whoever the applicant offers is non-sectarian. So that was our discovery work that we thought would help us along the way. Now, when we first went to district court, we had, ironically, the same judge that had the first of the three cases almost 20 years previously. And as we gained knowledge with time, he told us at the end of the oral argument that he thought we had done an excellent job and he was happy to be a stop on the road to higher appellate land. So at the district court, there really wasn't much that the judge could do other than rule in the state's favor, because we had a ruling of the First Circuit Court of Appeals. He was bound. We then went to the Court of Appeals for the First Circuit, which, for those who are keeping track, did not have a very good record before the Supreme Court this last term. Between our case, the Boston flag case, anyway, there were a number of instances where the Supreme Court disagreed with the First Circuit. There, we had a little bit more of a challenge because, of course, while precedent governs, there's the exception whether an intervening Supreme Court case has essentially fundamentally altered the state of the law. And so we needed to argue to the First Circuit that neither Trinity Lutheran nor Espinoza versus Montana, which came down right at the end of the time that we were before the First Circuit, had substantially changed the law in a way that the First Circuit should reverse its previous decision in favor of the Maine tuition program. And the First Circuit, our work paid off because they were very clear that the reason that they were not bound by either Espinoza or Trinity Lutheran was that Maine had been clear, and it was undisputed, that they did not discriminate based on whether or not the operator of the school was religious, only whether or not the program of education that was delivered was religious. So this was a distinction based on religious use and not religious status. And then we got to the Supreme Court, and all of you are on this webinar because you know what happened there. I wish I could tell you some great story about being at the Supreme Court, but the only one that sticks in my mind, ironically, is that the entire Supreme Court looks the same on the inside. Everywhere you turn, it's white. And so if you get off course, it's a good thing that there's a marshal standing at, well, pretty much 10-foot intervals, because you absolutely could not tell from the walls or the floor or the ceiling where you are. At any rate, those are some of the points that have come from actually litigating the case. If folks have questions about that, I hope to see them in the chat, or for Jess to tell me that they were in the chat. But let me turn it over to Attorney General Frey to talk about what's happened next.
Thank you, Sarah. And really, Sarah teed up what we had been sort of talking about from the beginning, right? That the two schools involved here, Bangor Christian and Temple, had acknowledged, which was, even if they were to decide that they wanted to apply to be a part of this program, there may be the overlay of another statutory structure in Maine that might act on just exactly what it would be that they would be able to do in their hiring practices and the way in which they treated their students. So the Maine Human Rights Act would prevent certain types of discrimination based on certain identified classes, as Sarah mentioned, sexual orientation, what your religion might be. These are protected classes in Maine by the Maine Human Rights Act. And Bangor Christian, Temple, as Sarah indicated, they didn't want anything to do with that. So in the event that we see applications from schools that have disparate hiring educational practices, there's going to be probably 3 ways in which we would see that litigation develop. Actually, 4 ways, that litigation to develop. First, an individual who's discriminated against, has their human rights violated, could bring their own Human Rights Act case. The Human Rights Commission, which is a part of the statutory structure to enforce the Human Rights Act, they could bring their own case against an institution, against a private religious school that's discriminating. The commission could bring their own. My office believes that we could bring a case if the Human Rights Act is being violated, that our authority does encompass the ability to protect citizen interests against the discrimination that the Human Rights Act prohibits. And then we have talked a little bit about this. I suspect that this will be part of the conversation with some of the other panelists as well. That next case in Maine may very well be a religious school applies. There is a question about their compliance with the Maine Human Rights Act. And to the extent that their activities, the school's activities, violate the Human Rights Act, the case might be, enforcing the Human Rights Act interferes with my sincerely held religious beliefs, challenging the Human Rights Act application on that religious program. So those are the ways in which we see future litigation around schools that apply to be a part of the program that are religiously based and discriminate. Now, not clear what the on-the-ground effect is going to be, as I think many of you may have already heard, although I don't know if it's been reported. There's been, I think, one application from a school that had not historically applied because they were concerned about this application of the law that prohibited religious programming. A second one is sort of sniffing around. And by the way, Bangor Christian, Temple have not applied consistent with how they their position in litigation. So the practical effect of this decision is really not felt yet. And statistically, there has not been any sort of evaluation that we could talk with this group about, or that we could share, that we have, that talks about the need for the current present system. But I will say the practical reality in Maine is that we still have very rural communities. We still have a need and a drive to make sure that every student in Maine has access to a complete and public education. And so the need to figure out how to do that is still there. There still is going to be a need for a system that recognizes that we can't build a high school in every single town, or an elementary school in every single town in Maine. I think there's around 400 plus political subdivisions in Maine. We just can't do that. So a need for a program that provides access using public dollars to ensure access to a public education continues. Now, when I was in the legislature, when questions like this came up, we're going through a political process right now. Every 2 years, the members of the House and Senate are elected. And for the first session, a member can introduce any bill they want and any number of bills they want. It will not surprise me if there is legislation either from members or from the executive branch, because the executive branch can put in legislation as well, that addresses this question that has been raised by Carson v. Makin's decision. I already know that the politics going on right now is bringing up school choice as something that is important to some members of the Maine electorate. I don't know if we're going to have a lot of firming up what's going to happen in the next legislature until after the elections, but I would be surprised if there wasn't some consideration, although I couldn't quite tell you how it would work out around what's going to happen now in making sure that public dollars are being directed to ensuring access to a public education for every school-age child in Maine. So I hope that provides some useful information for the introduction. Looking forward to the questions after the panelists.
Attorney General Frey and AAG Forster, thank you very much for giving us some insight into that process and what may be coming next, and the efforts you're making to ensure that all students have access and are protected from discrimination. Turning to you, Professor Green, widening to a national lens, what do you see on the horizon as potential results of the Carson decision, given that Carson opened the door to religious schools and instruction in public education? Where might we see efforts to expand that? One area that's been talked about has been charter schools. And I know you also recently co-authored a piece on the interplay of religious rights and civil rights post-Carson that I'm sure the audience would be very interested to hear about.
Well, thank you so much for inviting me to participate in this important panel, and I truly appreciate having a chance to discuss the importance of the Carson case. You alluded to an article that I co-authored with Dr. Suzanne Eckes of the University of Wisconsin titled "Carson versus Makin: Implications for Students' Civil Rights in Taxpayer-Funded Religious Schools," which was recently published by Canopy Forum on the Interactions of Law and Religion. We also wrote another article on the Carson case, which the journal Religion and Education will publish later this year. So in both articles, we explored the potential impacts of the Carson case on the funding of religious education. Now, with regards to the first question, we know that Chief Justice Roberts' statement in the majority opinion, which he originally made, I believe, in Trinity Lutheran, and I quote, "It is clear that there is no historic and substantial tradition against aiding private religious schools comparable to the tradition against state-supported clergy." That's a scary statement. So in other words, what they're saying is that there may be no historic and substantial state interest in preserving secular education. So as we noted in the Canopy Forum article, some may wonder if in a future lawsuit, the plaintiff might argue that no state can refuse to fund sectarian schools if there is no historic and substantial state interest in preserving secular education. So they're really hinting that they may be going very far here. Now, in the short term, efforts to extend religious instruction will probably be concentrated in states controlled by Republicans. So in 2021, which was hailed as the year of school choice, 7 states enacted new school choice programs, while 14 states expanded already existing private school choice programs. So the vast majority of these states were controlled by Republicans. So undoubtedly, the Carson decision will encourage even more effort in these states to pass and expand school choice efforts. However, it's important to note that rural school districts may provide a significant obstacle to school choice expansion in these Republican states. Because rural school districts tend to be very small, It may cost more money for these schools to provide a comparable education to their larger urban and suburban counterparts. So this concept is known in school finance circles as economies of scale. So many rural Republicans oppose large-scale private school choice programs because the loss of funding may make it impossible for them to operate their public schools. So in Oklahoma, for example, the Republican Speaker of the House recently refused to advance a school choice bill stating, and I quote, "I'm a rural Oklahoman. We see things through the lens of our individual districts." Similarly, rural Republicans have blocked the passage of private school programs in Texas because of their fear of the impact on their public schools. So that's something to be watching. We also explored the future of charter schools considering the Carson ruling. Because charter schools are generally defined as public schools that must operate in a secular fashion, this case does not seem to impact them. However, charter schools have many private characteristics that could cause the Supreme Court to define them as a private school option. For instance, a big concern is that they are privately operated. So if the court were to rule in this fashion, then prohibitions against religious charter schools could be categorized as religious use restrictions. And as Carson has now shown, religious use restrictions are now constitutionally vulnerable. Indeed, Justice Breyer, in his dissent in the Carson case, wondered how charter schools stood in light of this decision. And it's important to note that the Supreme Court may soon get that opportunity. It is deciding whether to accept an appeal to a Fourth Circuit Court of Appeals ruling in a case titled Peltier versus Chartier School. So in that case, the Fourth Circuit held that charter schools are state actors under the Equal Protection Clause of the U.S. Constitution. The state action doctrine provides that governmental entities must comply with the U.S. Constitution, but this requirement does not apply to private individuals or organizations. And the charter school is arguing that it is not a state actor. So we should be paying attention to the Peltier case or other cases that the Supreme Court may be ruling in the near term.
Thank you very much, Professor Green. A lot to think about, and the questions are also pouring in on these things. I want to turn to Dr. Jackson. We're very eager to hear from you as well. And let me pose a few questions that we're hoping you can give us some insight from your position. Private school voucher proponents have recognized that state legislatures offer one of the clearest paths to enacting their favored policies, as Professor Green was just talking about. And so they've really organized in the state. So one question we have for you is, how can public school advocates respond to this in the states? And also how those efforts dovetail with advocacy for fair school funding. How can we ensure that a diverse range of stakeholders are involved and included in grassroots efforts on these issues? And also, how do we encourage the involvement and support of philanthropic organizations? So I'll turn it over to you.
Thank you, Jessica, for the question, and it's an honor to be a part of this discussion. First, I would say we have to remember that the majority of students in the U.S. attend traditional public schools. Yesterday, today, and very likely tomorrow. And I say that to say that we can't lose sight of this battle around ensuring that those traditional public schools have the resources to offer those young people and their educators the capacity and the resources that are needed so teachers can teach and students can learn. To the degree that we miss the ball on that, it helps build the narratives that we hear for the need for private voucher programs, private schools, but we've got to win the battle and continue to fight the battle for fiscal equity. And I say that well knowing that it's something that the Education Law Center has been on the forefront in doing for nearly 50 years now, but their work, that advocacy is still needed as we move forward. Secondly, as it specifically relates to the Carson v. Makin case, I think the decision that we received, unfortunately, was reflective of the politics of the court more than it was the precedents of the court. And what I mean by that is we can't leave this to be a jurisprudence conversation. Simply put, elections have consequences. So if we care about this particular issue, if we care about the discrimination that's occurring, we have to also care about the voter disenfranchisement that happens across the country, the scrubbing of the voting rolls. We have to unsilo these issues. This is something that this is a space that we don't often talk about within the education context, but when they're able to disenfranchise voters, they're able to create courts, they're able to create systems that are not reflective of all of the opinions and the voices of people who should be a part of our democracy. So I say that to say that, yes, this is a critical issue that we must discuss, but we also can't just discuss it in the space of jurisprudence, but it's got to be discussed and voted on in the space of midterm elections and the elections that happen each and every day. Now, we're where we are right now. The Supreme Court has made this decision. What is it that we can do, and what is it that we should do? At this point, we have to be the watchdogs for the type of discrimination that we heard both Aaron and Sarah talk about. You cannot accept public funds and discriminate. And it is going to take grassroots advocates across the country where you see these schools who are receiving these public dollars discriminating in all of the ways that Aaron and Sarah outlined to really call a question. Number one, as a former employee of the Office of Civil Rights at the Department of Education, filing complaints against those schools that are discriminating against sexual orientation, gender identity, and of course, race and gender. We've got to hold those schools individually accountable. Number two, when you can't win the case in the courtroom, you go to the court of public opinion. And the court of public opinion is influenced by advocacy, protests. Those are things that we can't leave out of the tools that we can't leave out of this battle. I will also say that we have to elevate the platform of our traditional public schools beyond just a place of instruction. Our public schools are platforms of support for children and families, support that speaks to healthcare in certain instances, access to healthy food, access to transportation. These are all supports that there's no private network of schools that are able to provide. We have to ensure that we're elevating the community school model. There are a number of philanthropic organizations that are helping grassroots organizations do this, like the NEA Foundation, the Hewlett Foundation, of course, Schott, and Communities for Just Schools. And finally, I would say that we've got to ask the question, should institutions, should we further these types of tuition programs? Much in the same way in 1954, Thurgood Marshall called the question, can separate ever be equal? The question before us is whether or not sectarian private schools could ever operate their personal sectarian mission without discriminating. And this is a question that we have to continue to elevate and put front and center. One thing that COVID taught us, there are a number of ways in which we can use technology to reach those students, especially at the secondary level, who need educational instruction where there are no traditional public schools. We've got to begin to explore those alternative avenues in a way that's equitable, in a way that provides opportunity and high instruction. But at the end of the day, ultimately, from lawyers to grassroots advocates alike, we must hold the line and send a clear message that if you choose to be funded by public dollars, you cannot discriminate in private.
Thank you very much, Dr. Jackson. And I want to pick up on one of the themes of your remarks and ask the other panelists if they'd like to add the idea that the attacks on public education are not isolated, not an isolated issue. At Public Funds, Public Schools, we talk about how public education is one of the cornerstones of our democracy. And I think that then lends the question, what are these attacks on public education also attacking? We've talked about how there are attacks on the public good, on other public institutions like voting rights that you mentioned. Do any of the panelists want to talk a little bit about the even broader implications of the Carson decision and the attacks or the undermining of public education? Go ahead, AAG Forster.
I wanted to add one thing that, of course, I thought about as soon as I stopped giving my introductory remarks, which was one of the most profound things, thinking about what Drs. Green and Jackson said, that came up at oral argument. The issue was raised that public schools teach values. And in fact, they do. It's undisputed. You could look at the website of any public school system and it would have its overarching values. And the suggestion was made by more than one justice that sectarian schools were simply teaching a different set of values, and that was along the same spectrum. In other words, there was an equation in some of these justices' mind between the secular values that appear in a public institution and the sectarian values being taught in the religious schools, and that somehow, to a parent, those things were of equal significance. And correct me if I'm wrong, Dr. Green, but when I read what you're talking about, that's a sea change. The idea that secular and sectarian values aren't just in the same ballpark, they're just 2 points on the same continuum.
Yeah, I totally agree. And that they're even going farther in their actions, even going further to say that, that sectarian and the issues surrounding that are trump civil rights and equal protections against discrimination. And, I do find that to be very concerning. In fact, I always, when I think about my early writings on this issue, I cringe sometimes because I totally think that I did not completely understand the implications really about, student rights and protections, and that that's something that public education and public schools really do support, is that protection for student concerns and student rights. And the valuing of, and I think what could be coming pretty shortly is that these protections will no longer be valued, they will no longer be lifted. And that is very concerning for students of color, for students with disabilities, for anyone, for whom protections are in place to guard against discrimination. So it's very concerning, and it is something that I'm very worried about.
We've received a lot of pre-event questions and questions during the event on increasing accountability and transparency in private schools that receive public funds. I'll frame this by saying that it's public funds, public schools' position that voucher programs need to be halted and rolled back. But there are, with Maine's program being different from a voucher program, but voucher programs in general needing to be halted and rolled back. But there are numerous existing programs, and Dr. Jackson mentioned, the core question of whether such schools could ever be regulated sufficiently to ensure non-discrimination. But on a practical level, with all the programs around the country that are providing public funds to private schools, what can the panelists tell us about efforts to increase accountability or just transparency and data collection so that we know more about what's going on in these schools? Maybe you can tell us a little bit about what's in Maine and what's around the country and what can be improved. And Dr. Jackson, maybe efforts you've seen to improve that transparency and accountability.
Well, I'm going to look to Sarah for some of this because she advises the Maine DOE on it. I mean, part of the challenge I think that we're going to be facing with how Maine continues with its program is aligning how these dollars are going to be going out in order to meet the purpose that the program is really designed to meet, right? Which is ensuring access to an education that is consistent with what, develops civic engagement, exposes children to different ideas from what maybe they, preparing them to be engaged citizens. And on the other side, there is a social equity discussion that we've talked about before as to, those with means may be able to have other opportunities that those without can't send their children to. Getting to the accountability and data collection, I think that there probably should be a conversation about maybe providing more specific legislatively directed guidelines on what constitutes a public education, making sure that that's clear so that, that can be, something that and Sarah's going to correct me or jump in on me here if I'm not getting this right, but that was something that was really challenging for the litigation with Carson v. Makin, because pointing to what those standards were that you could then hold a public education program accountable to, or that you could expect students would be exposed to. I guess I would suggest, without committing my office to that, I would suggest that might be an area where we could see some development that would improve on that question of, are we getting the education that we're paying for that does what it is that we hope it will do to prepare, through public education, prepare Maine children to be engaged, informed community members. I don't know if that gets to your question, Jessica. Sarah's going to clean it up for me if I messed it up.
So here's where I step in as an agency attorney who represents a large state agency. So much of this rests in the hands of state legislators, because a state legislature can be very specific as to the things that their state Department of Education or Department of Public Instruction, or however it plays out in the various states, can require of private schools that seek public funds. This case was all about whether they could be sectarian or non-sectarian. This case was not about whether or not they were required to provide audits, whether or not they were required to submit their curriculum for review and approval. And all of that is bigger than sectarian schools. Arguably, this is a question about what do we expect from any school, public or private, that is going to provide a public education. And so Aaron is the former legislator, I am not, but the truth is that's where the power lies. And the Supreme Court has said, starting with Zellman versus Simmons-Harris and the first expansion of the possibility of including sectarian schools in tuition or voucher programs, this doesn't stop states from regulating them.
And I would like to piggyback on what Attorney Forster has said, and to think that if we're going to do this, we should be thinking about this in terms of like publicness. And that's like publicness in that we have to be thinking about how money is spent. And I've done a lot of work on charter schools, for instance, where arguably the regulations and oversight maybe there more so, but we're seeing all kinds of issues with like real estate spending, money going into various related parties, and then money not being able to be tracked. And so I think that some of the issues that we've seen with charter schools, arguably where there may be more regulations, I think are very concerning as we go towards like more privatization and even greater or even less oversight. And so some of the issues that we're seeing, or some of the exposés that we've seen in the charter school realm, could certainly happen more so in the voucher realm. So I think that we definitely need to be thinking about, if we go in this direction, I'm not saying that we should, but if we go in this direction, state legislatures do have to be thinking about how to regulate them, how to ensure that money can be followed and that it does not go into a black box as soon as it goes into these entities.
And I think that one of the things that should be a must is these schools should meet the data collection requirements that traditional public schools who receive state funding also should meet, both at the state and federal level. Data requirements of the Office of Civil Rights at the Department of Education. And why this is important is because it's a point that Assistant Attorney General Forster just mentioned. While our schools have always conveyed Commonwealth values, values around democracy, values around opportunity, whenever those values begin to convey individual or push individual assessments or values, federal government from an equity perspective has stepped in, meaning even if there is a policy that doesn't say Black students should be pushed out. If in practice, you look at the data and it's more likely for Black or brown students to be suspended or expelled. As a value proposition, the federal government or state office of civil rights would step in and regulate that. That's why I believe, and I agree with the Assistant Attorney General, that the values of our Commonwealth are much different than the sectarian values that are being offered, because many of the sectarian values are not only speaking of Commonwealth values, but more personal values. I am better or less than because of my identity, whether it's gender identity, sexual orientation, or what have you. And that's something that has to be regulated by data collection, even if it's not explicit in the law. If the outcome produced a result where a certain class of students based on race, ethnicity, gender identity, or a certain class of educators are pushed out or not advanced based on their identity, that's what we need to know. Those are the data that we should collect so that we can step in and eliminate those challenges and forms of discrimination.
Here's another question from our audience. What legal hurdles are there to a state simply deciding to stop funding all sectarian schools and instead committing financially and otherwise to high quality public schools everywhere? I'll start out by saying that one of the, I think, legally cleanest ways to avoid now funding religious schools is not to fund private schools, given the Supreme Court's recent opinions. But of course, there are a variety of circumstances around the country.
Yeah. Thank you for that prompt, Attorney Levin. I think that one of the unintended consequences, I think, from the perspective of those who want to see school choice expand, is that in states where they don't have it, they just won't do it. Because they may feel that they just don't have any real control over how those schools operate. So I think that, and that's something that we touched in on our articles, that this may be an unintended consequence. They'll just not do it. I think what else may occur is that in some states where they have programs, they then place a cap on them or just stop operating them altogether. So I think that you may also see that in states that just don't want to go in that direction, that this will possibly create a limitation to the expansion of these programs.
Yeah, I think it's clear that the Supreme Court said that if you have these programs have to be open to all types of private schools. Under that situation, the major hurdle, in my opinion, is how do you provide high quality educational services to students that are not located in proximity to traditional public schools without providing a private school funding option. And that's the space that I think philanthropy has to step in and support the various forms of innovation to provide instruction to these students in a way that's equitable and high quality. Otherwise, I'm not so sure that leaving it to the individual states to manage is going to lead to the outcome that we desire.
I'll just add from the Supreme Court opinions we've been talking about that that Chief Justice Roberts, particularly his opinions, have been clear that states do not have to fund private schools. And that was repeated in the Carson decision, which was very nice to see.
Sure.
Another question from our audience, from someone who teaches law students. What advice do our panelists have for law students and young lawyers? And let me add students as well, other students, regarding how they can advocate for students' public education generally and adequate funding. I'm sure you all have a lot of wisdom on this, but if you can give us maybe each a few pearls or what you think, areas to concentrate on, ways to get involved, and some inspiration for our audience members.
I guess I'll go. I think when I was at Penn State for several years, I had struggled with this issue because I had gotten into law school, was interested in law and interested in education, but was trying to figure out a way to actually use those skills. And so I developed a joint degree program in law and education to try to address this. But I think that one thing that I found, and I've spoken to students and have looked at this over the years, is that I do think that we have to spend a little more time actually teaching about education and law. And because a lot of law schools just don't do that. And I think that, education, a lot of these issues about administrative law, constitutional law, and so on, all happen in education. And in fact, education is it's basically these issues in an applied fashion. So I think that if we can actually, teach these things and then explain to students that they can do a lot of good, in the area of arguing for civil rights and arguing for protections through education, that, I think that goes a long way, I think, towards teaching students that education could be a field where they can do a lot of good with the law.
For high school students, I recommend Jamie Raskin's book, We the Students, which goes through the Bill of Rights using student cases as an example. I think that that's something that is very empowering to young people to be able to see how cases involving their existence form the basis of important law throughout our Bill of Rights. And for law students, I can't believe I'm going to say this, but think about taking a course in administrative law. A lot of education law comes from administrative law. And for all citizens, learn how your government works, because people want to do things, people want to be active. And it's amazing to me how many of us have forgotten what we learned in civics class about who's responsible for what. So think about learning more about how your government actually works.
One other thing I'll add too, and I mean, I think in a lot of the work that I'm doing now is that, especially now that public and private are blurring, is that, again, like some of the white collar crime issues, a lot of these issues that we're seeing now are happening in public education. And so I think that even in those courses that may seem to, on first glance, not have a public education or education connection, I think are now having more and more of that connection as we're seeing them playing out in charter schools and in private schools and so on. So I think even the traditional sort of law school curriculum can be very helpful in some of the education issues that we're now seeing.
I guess I just want to add from a little bit different from using the law. I mean, the decisions that are made about how funding is going to be directed to public schools, about what sort of direction is going to be provided for that education. It's happening in the legislature, and it's happening at the local school board level, for better or worse, right? I mean, we see very contentious conversations going on across the nation. That's happening here in Maine. And so the extent to which there is a question about how is it that one might be oriented to advocating for the importance of public education, for the importance of adequate funding, those conversations are happening in the legislature. They happen with every budget that is considered, at least for Maine, and I have to imagine this is the same across the nation. Your state legislatures are making decisions about what's important in that budget and advocate for that funding to be directed towards public education. And fighting programs like voucher programs or school choice programs that dilute the ability to provide that public education. That voice has to be, patient, direct, informed. And then, of course, at the municipal level, we see this happen with public education as well, where you might have one school board that, puts a little bit more priority on ensuring adequate funding for a broad range of public education access, where a school board in a town 100 miles away has different priorities, like keeping the tax rate down or something, right? Advocating at the municipal level, at least for Maine, can't say this is the case across the nation, but providing public education is a very powerful local control activity. And so if you're asking people to, how do they get involved? Talking at those different levels and engaging with those people making the decisions could very much go along. It did for me, went a long way for me when I was in the legislature. It might go a long way for these folks as well.
Dr. Jackson, you told us about some of the strategies that you think are most effective. Did you want to add anything about inspiration for our audience about how they can get involved?
Well, I think they covered it. I benefited, like Dr. Green, from a joint degree program, law education degree at the University of Illinois. But I would say that when I worked with the NAACP, it was parents, it was young people who were advocating for these types of change by organizing. That is just as effective as some of the legal tools that we use. So I would say get in where you fit in. You, as an advocate, as a parent, as a young youth organizer, if you should so decide to go the law school route, there are opportunities to understand the legal terrain as well as education. But at the end of the day, you are already empowered and you have what you need to become an effective advocate. It's just a matter of the additional tools that you would like to add in order to push for the type of equity that our young people deserve.
Thank you very much. We've had some questions come in about current voucher litigation. What is the state of pushing back on voucher programs around the country? I will say briefly that there are a lot of voucher challenges around the country right now. To name a few: Kentucky, Tennessee, West Virginia, Ohio, North Carolina. In several of those states, the voucher programs have been enjoined by that litigation. It's been successful efforts, and the push continues. Please remember, we will have a whole webinar on voucher litigation coming up in a few months. But for now, and I'll just mention that there are still voucher programs being passed around the country, like in Arizona, and there are fantastic public school advocates, including those on this panel fighting for public education, and around the country, including so many in our audience. So thank you. For now, I want to thank our wonderful panel for all of the insights that you've given us today. Thank everyone at Education Law Center who helped set up this event, and also our audience for the wonderful questions. We could only get to a fraction of your questions, but thank you for being with us today. Please feel free to contact us and follow up. And thank you for joining our webinar, Post Carson v. Makin, How Can We Protect Public Education? Sign up for the additional webinars in Education Law Center's 50th anniversary series, and we look forward to seeing you all soon. So thank you so much.